Hello everyone, my name is Linda Gamester and I am an employment solicitor here at Bayani HR and Employment Law. I wanted to put together this short presentation for you as we've recently had a very interesting case handed down from the Supreme Court, which will have a fundamental impact on how holiday pay is calculated for part-time workers. Firstly, I would like to tell you a little bit about us. So we are a specialist HR and employment law firm and can help your business with everything from contracts and handbooks to tribunal claims to training. We are a one-stop shop for all your people management needs. We support hundreds of clients and businesses on our fixed fee HR support package called Watertight HR and Legal. There are a range of packages available with the aim of providing your business with a cost-effective HR solution. So if you want some more information about this, please visit our website or give us a call and we can talk you through a personalised quote. Now moving on to the case then. So this presentation focused on the recent decision handed down by the Supreme Court in the case of Harpur Trust and Brazel, and this is about holiday pay for part-time workers. But you might be wondering, why do I need to know about this case? Well, if you employ zero-hour workers, part-time or casual workers, including those that only work term time, then this decision may have a huge impact on how you calculate holiday pay. This case is of particular relevance to workers that don't work for the full year. So you might only offer them hours one week, but not the next, or they might only work a few weeks out of the year for you, but you've got them on an open-ended or permanent contract. So what happened in this case then? So this case is about Mrs. Brazel. She's a music teacher. She worked part-time at a school. She was only engaged during the term time as the school obviously wasn't open during the school holidays. She did have a permanent contract though and was engaged term after term without a break in that contract. There was no obligation to provide her hours, and on average she only worked about 32 to 35 weeks out of the year. Her holiday was changed and it was paid at the rate of 12.07% per hour that she worked, which was it's a standard calculation. Lots of companies use this, and at the time that the school were doing this as well, this was what was recommended by ACAS, so it was in the ACAS guidelines for calculating holiday. Mrs. Brazel, however, wasn't happy with this. She argued that she was in fact entitled to 5.6 weeks of holiday pay each year, even though she didn't work the full year. And she wanted that to be calculated on the previous 12 weeks of pay. Initially, this claim did fail in the employment tribunal, who took the approach that actually the payment of 12.07% was fair, and that she had received her full holiday pay entitlement. However, Mrs. Brazel appealed, and the Employment Appeal Tribunal found in her favour. They actually found that the working time regulations didn't support pro-ratering, and therefore Mrs. Brazel was actually entitled to more holiday pay. The trust appealed this further, and the case went up to the Court of Appeal. And again, actually, the Court of Appeal found in favour of Mrs. Brazel and agreed that there was no foundations for pro-ratering, and the correct approach was in fact taking into account the full year's service. So this case went further and it was appealed all the way up to the Supreme Court. Now the Supreme Court also agreed with the Appeal Tribunal and the Court of Appeal, which meant, or now means, that we need to be seriously considering how we calculate holiday, because what they have found is that the calculation using the 12.07% is incorrect. And actually we need to be taking a whole different approach called the calendar week approach, or the calendar week method, in order to calculate holidays for part-time workers and term time workers. So firstly, let's look at where does this 12.07% come from. I know lots of my clients use it, particularly for their casual workers, and like I said, term time workers particularly. It's a very popular method to calculate holidays for those that do work sporadic hours and aren't consistently working throughout the year. So ACAS, as I said, did recommend this. Obviously now they have taken, they've removed this guidance from their website, but it was thought to be a fair representation for those who worked irregular hours. And the way that it was calculated was that you take your 52 weeks in a year, you take away the 5.6 weeks holiday, which is your statutory minimum holiday that you're entitled to, so that leaves you with a 46.4, and then you look at the percentage. So 5.6 weeks is 12.07% of 46.4 weeks. So yeah, lots of maths and calculations there. However, just for an example, you've got a worker that works 100 hours in a month, they're paid £10 an hour. 12.07% of the 100 hours is obviously 12.07. Times that by £10 per hour would give them a payment of £120.70 for holiday pay. So as I said, this was particularly relevant for those that work for short periods, and although the employers shouldn't be paying lump sums for holiday for those that are engaged for longer periods, it has been common practice for some time that if you are particularly in between assignments, that you'll receive a lump sum for your holiday pay based on this calculation. Okay then, so what difference does this actually make to you as an employer? And initially the court considered 3 different approaches to calculating holiday pay. So the first one is the calendar week method, which is the approach that Mrs. Brazel argued should be applied to all part-time workers. And what this does, it takes an average over the last 52 weeks and it ignores any weeks that aren't worked. So that's quite important. You then multiply this by 5.6, multiplied by your hourly rate will give a payment. So as an example in this case, at the time this case was heard, the reference period was in fact only 12 weeks. So we are only looking back, when we're looking at Mrs. Brazel's holiday pay, we're only looking back over the previous 12 weeks. Whereas now we would be looking back over 52. The other thing to bear in mind as well is that Mrs. Brazel was paid at the end of each term. So she received 3 instalments of holiday pay each year. So if we look back at what she earned at the time, so if you went back over 12 weeks, she worked for 149.5 hours. Ironically, the term was only 10 weeks long, but because we're ignoring any weeks that aren't worked, they took 2 weeks from the previous term, even though that there were a few weeks break in between that. As I said before, Mrs. Brazel earned £29.50 an hour. So we look at what that entitles to as an average weekly pay, and we get £367.52. So you take that, times it by 5.6 weeks, divide by 3 to get her term time calculation, and that would have given her a payment of £687.26. The next approach that the judges considered was the percentage method, which is the 12.07%. And obviously this is the approach that the school wanted to take. And this simply takes the number of hours worked, which, as I said, was it was actually less. It was a 10-week term. So she only worked 127 hours, times that by the 12.07% by her hourly rate actually gives you £452.20. As you can see, there's quite a big difference in the holiday pay there. So a middle ground that was proposed by the trust was the working year method. So this only specifically applies to those that do work part-time throughout the year and only work for specific times in the year. So it actually works out how many weeks out of the whole year did you work, take that as a percentage, apply the calendar week method in terms of going back, getting your weekly pay, and then multiplying that up. So in this case, she worked 34 weeks out of the 46.4 working weeks of the year, which gave 0.73, times that by the 5.6. So what that meant was, if you use this method, she's only entitled over the whole year to 4.09 weeks of holiday. Again, divide by 3 just because she received three 3 payments throughout the year, and that gave her a payment, or would have given her a payment, of £499.83. So again, looking at this, that is significantly cheaper than the way that she was arguing it should be calculated. But that was the middle ground that the trust wanted to take. The courts rejected that. They said that the correct way of calculating is the calendar week method, and the reason why they reached this decision was purely based on the wording of the legislation that we have in place at the moment, which deals with calculation of holiday pay. So hopefully now you're seeing that this could have a really big impact on your business, particularly if you do use the 12.07% calculation method. So the initial question is, right, who does this actually apply to? Firstly, it doesn't matter if you have employees or workers, as you should be aware, workers are entitled to holiday pay too. So we're not making a distinction on that basis. And it doesn't just apply to term time workers. So you might be hoping, well, she was a term time worker, she was a teacher, it won't affect other industries such as like hospitality, entertainment, all those other ones that really rely on things like 0-hour contracts. Unfortunately, it is going to affect you. It impacts any hourly paid worker who works irregular hours on a permanent basis. So the key part here is they've got to be on a contract that doesn't have an end. So 0-hour contracts, casual workers, term time workers, seasonal workers. If your contract doesn't even have to guarantee work, but if it engages that person for an indefinite period, then they will be seen to have been engaged for the whole of a holiday year. Also, this is particularly going to impact those that don't work certain weeks of the year. So that could be that they don't work it because you are closed, they don't work it because you just don't have hours for them during that time, or that is just how your business runs in terms of you need more staff, say during the summer holidays, you quieten down over autumn, then you bring back those staff again under the same contracts in the winter months. It's unlikely to affect salaried workers though, so that's a key part of this when we're going to look at how we can get around these issues. So now you're seeing the significance of this and how much this decision could potentially cost your business. What do you do now? What are the next steps? And the first thing is you need to review all your contracts first of all. You need to see how you are engaging all your part-time workers, what contracts they are on, and how you are paying them. What is the calculation method you're using at the moment for holidays? If you're using 12.07%, then the courts have categorically said that is wrong. So we need to stop using that method immediately and look at alternatives. Also, unfortunately, bad news for everyone, this does mean that the floodgates could open for claims to be brought for unpaid holiday pay. So even though the law has only just changed on this, and at one point ACAS was saying this was the right thing to do, it does open us up now to back pay, and therefore you need to be looking at liabilities in terms of, right, how long have I been paying these employees this amount? How much could this potentially cost me to remedy, particularly if all those employees then decide to go to the tribunal to bring a claim. The other key question I know we're going to get asked is, well, if we can't use that method, how are we going to calculate holidays? What is the right way? Well, the legislation itself is quite sparse on exactly how we should be doing it, but the best we can do is send you to the government guidance, which is there is a guidance website on gov.uk, which is they've got a document on there called How to Calculate Holiday Entitlement for Workers on Different Types of Contracts. So that is what we're going to be referring to now, because for us that is going to be the safest way and the safest advice we can give you when we're telling you how to do your holidays. So our top tips and final thoughts, given the massive impact this is going to have on so many sectors. Firstly, if you have workers who, like I said, are on these contracts that are rolling, but they only do a short, they only work for you for short periods, they are going to benefit the most from this. And an example actually that was given in the employment tribunal case was the one of an exam invigilator who is on a contract year after year to do 3 weeks of work. Because they have a rolling permanent contract, but they're only working 3 weeks out of that whole year, using this method means that they're near enough entitled to twice as much holiday as they are paid for the actual time that they work. It's bizarre, and it's not a fair outcome. We're not saying this is a fair outcome. Even the courts have said, we acknowledge that this isn't going to give a fair result for everyone, and potentially those that work the shortest amount of time could end up with the most holiday pay. But their decision on this is that that's actually a Parliament problem. So Parliament's put in place the legislation. They're the one that have created this policy and the wording that we are going by. Therefore, it's for them to change this. But, what can we be doing now to sort this out? Firstly, in terms of knowing about your liabilities, workers have 3 months from the date of the last unlawful deduction in order to bring a claim in the tribunal, and potentially they can be claiming up to 2 years of back pay. There are some rules around this that we would need to look at, and we would want to be looking at this on a case-by-case basis, because whereas one employee might be entitled to 2 years of back pay for holiday, one may be only entitled to a few months. So it's going to be different for different employees. If you do recognise that there are some significant liabilities for your business, then you might want to start consulting with those employees to try and reach a compromise now. That could be staggered payments, it could be seeing if people agree to reduced payments, but I would say that just ignoring this problem could open up a big can of worms for you, and one way or another you may need to address the payment of holiday for your employees. Going forward then, how are you going to protect yourself from this? Well, look at the contracts that you're using. Consider maybe using genuine fixed term contracts whereby there's no expectation of further work once that contract has expired. As I said, this case only really deals with those that are engaged on an open-ended basis for the whole year and it's permanent, whereas if you are only engaging someone for a very set period, you would be entitled to pay them a prorated amount of holiday for the time that they have worked for you. The other thing you might want to consider is using self-employed contracts. Now this potentially has its own issues. It's got to be the right kind of work. They've got to be genuine self-employed people. You can't just dress up your workers and your staff as self-employed to suit your own needs. So you may want to take some advice on that before you start using self-employed contracts. The other thing you could consider doing is, particularly like with 0-hour workers, is giving them either a small amount of money per week to engage them. So you might give them an hour or two a week, or you could convert them to salary whereby they are salaried throughout the year, they get a lower amount even though they might not work throughout the year. I'm not saying any of these solutions are ideal and will be suitable for your business, but they are options that are now open to us to try and avoid this unjust and this unfairness, and also the cost to your business as well. As I said, I don't believe that this gives a fair outcome for all part-time workers. One thing the courts were very clear on is that there is no rule in place that says that we can't treat part-time workers more favourably. They have protection from being treated unfavourably or unfairly, but there's nothing that is stopping an employer from treating them more favourably. So, are the government going to do anything about this? Are we going to see a legislation change? I don't know. We will have to wait and see. But for now, this is a problem that we've got to deal with, and we are encouraging particularly our clients get in touch with us because this could have some really big repercussions for your business. So that brings us to the end of this short presentation. I appreciate it's been a bit of a whistle-stop tour of what is a really big change in how we're going to approach holidays. But if you do want any further advice, get in touch with us. I've also written a blog about this which contains a bit more detail about what I've discussed today, so please go to our website, have a read of our blog. If you are one of our watertight clients, get in touch with your dedicated advisor who'll be able to give you some more information about this. We will help and guide you through this process. If you are not one of our watertight clients, then get in touch. You can receive the same support that hundreds of clients across the country receive every day from us. So stay in touch with us, give us a call, email us, anything you need. And yeah, we hope that we'll be able to work with you soon. Okay, thank you. Bye.